So welcome everyone today. We have a special presentation on an important topic today from Melissa Carter. Melissa is an attorney, also happens to be our board president. So this is really a treat to get to um, learn from her and kind of see her in her professional realm. So she's going to be discussing today navigating personal injury claim after TBI. And I imagine there will be lots of questions, lots of personal experience that people have had in this space. So please know this will be recorded. And at the end of the recording, at the end of the presentation, I will stop the recording and we will get to your questions. And I look forward to you all bringing that forward. Melissa is lovely and has offered her time and her expertise here today as a resource. And that's really a gift for all of us. So thanks, Melissa, for being here and go for it.
Well, thank you so much, Reggie. And I just want to make sure, a quick sound check that you can hear me okay. All right, I'm using a slightly different microphone than normal. Really nice to meet everybody here today and good morning. As Reggie mentioned, my name is Melissa Carter. I am on the board and currently serving as the board president for Brain Northwest. And I've been involved with the board and doing a lot of community work for this wonderful organization for about a decade or so. And in my private law practice, I've been representing survivors of brain injury and helping caregivers for a very long time. I've been practicing as an attorney for a little over 25 years now, and started my practice working on the insurance side of things, defending claims. And that did not bring me joy in any way, but I did learn a lot about the process and what goes into evaluating injury claims from the insurance side. But once I moved over to the representing individuals and helping people, my career had meaning and life got a lot better for me personally. So this is truly an honor for me to get an opportunity to speak with all of you today and see how I can provide any kind of light or answers during a really dark and scary time. So I've put together a presentation, general overview on how to navigate the claim when you've suffered a traumatic brain injury and you have some sort of insurance or legal claim against the entity responsible for your injury. I've got plenty of time at the end of the talk to address questions. And as Reggie mentioned, it'll be after the recording turns off, so people feel a little more safe and know that this is an entirely confidential, secure process if you do ask questions. I will have my contact information up on the screen at the end of my presentation as well. So if anyone wants to reach out one-on-one by email or by phone, I'm certainly available as a resource as well. So let's talk about the overall navigating a personal injury claim and what that involves. Today, what we're going to talk about is just kind of the basics of what an injury claim is and what it looks like, what the deadlines involve, how you can best gather evidence to support your claim if you've suffered some sort of injury, what it's like to work with professionals in this environment, from attorneys and insurance representatives to medical folks as well. What goes into proving what's called damages in the claim? That's when you settle a case, how the amount of the settlement gets determined. And then how you can make the best informed decision for yourself and your family when you're involved in a situation like this. So a personal injury claim. Um, it involves compensation for your care related to your injury. It involves compensation for income that you may have lost or will lose into the future, and also a level of accountability for whoever has caused the harm, whether it's an individual or a corporation. There's two different types of paths that are involved when you have an injury claim. There is a settlement with an insurance company, which tends to be faster, or there's a lawsuit, which is a little more formal, takes more time, and involves a judge and a jury in a courtroom setting. I'll talk about both And maybe some people on this call have been involved with that process already, and you may have some stories to share as well. I love hearing those stories. The key players that are involved in these claims are the plaintiff, that's the injured person, you, if you have suffered the injury, or your family member, if they have suffered the injury. The defendant, that's the at-fault entity, the person you bring the claim against. For instance, if it's a car accident, it's the at-fault driver. They're known as the defendant. The insurance representative, and they are called an adjuster. And if you get an attorney, then you'll have an attorney involved as well. Not everyone has an attorney during this process. There are some very important timelines and deadlines you want to be aware of if you have an injury claim. Missing a deadline can completely dissolve your claim. Even if it's a really big injury claim, if you miss the statute of limitations deadline, the claim expires. Every state has a statute of limitations, which is the amount of time you have to bring and settle a claim from the time of the injury. In Washington state, statute of limitations is 3 years if you're an adult. So if you're 18 or older when you were injured, you have 3 years to resolve your claim. If it's a child, then the statute of limitations doesn't run until that person reaches the age of 21. And then there's an additional 3 years after that. Or I'm so sorry, until the age of 21. So the statute runs once they turn 18. You either need to file the lawsuit by that time, the 3-year time, or settle the claim by that time. Some other stages and timelines to follow during a claim include the investigation stage. So immediately after the injury happens, there will be gathering of evidence and information. Also during the investigation stage is the opportunity for the insurance company to ask questions of you. If a lawsuit is filed, that means taking what's called depositions. And there's gathering of expert reports during the investigation stage. And finally, there's negotiations with the insurance company trying to resolve your claim. The resolution process, that's when you either go to trial and get a verdict or you sign a release and you have a full settlement. I'm going to talk in detail about each of those, but this is just kind of a big roadmap on what we're going to be talking about today. So the claim process at a glance. First and foremost is the incident that caused the injury. Very frequently, this is a motor vehicle collision. That's what we see in our practice more often than other claims, but it can be any kind of injury that caused a brain injury, incident that causes a brain injury, such as a slip and fall at a premises. That can be at someone's home or at a professional place of business, such as a shopping mall, a grocery store. It can be a sports-related injury, or, as I mentioned, motor vehicle collision. Whatever caused the injury, we need to determine if there was negligence involved. If there was negligence involved, then you will have a claim against the negligent entity. The next step is getting medical care, and that is by far the most important piece of every claim: medical care, getting better, access to the right professionals who can help you. And if you take away anything from this talk, is this: your greatest wealth is your health. And focusing on your medical care is much more important than the settlement. The settlement is helpful to obtain that care, but focusing on your care is by far mission number one. Also part of the claim process is gathering evidence and then filing a claim with the insurance company and then ultimately negotiating a claim and resolving it. So I mentioned a few times documenting the incident. What does that mean? Well, we'll talk about the example of a motor vehicle collision. If there is a car crash that you're involved in, either as a driver, a passenger, a pedestrian, or a cyclist, any kind of involvement with a motor vehicle that results in injury to you, the most important thing at the scene is gathering information. Sometimes folks are not conscious after the injury and they are transported to the hospital. and they have no way of saying what happened. They may have short-term memory loss, or they didn't see what happened. Wake up in the hospital room and have no idea how they got there. So getting a consultation with someone who knows what they're doing as soon as possible so they can help gather things like 911 calls, which are only preserved for a short amount of time, that can help us find witnesses who may have called 911. Getting copies of the police report is crucial to do. It's actually pretty easy to get the police report if you have access to the internet, computer. There's a way to request the report. If you don't have access to that, then there are tips that we can help you find someone who can help you get the police report. Uh, in the police report, there are frequently witnesses identified. So again, this is all to establish the evidence to show who was at fault, because you need to have negligence on the part of the at fault entity to actually succeed on a claim. Sometimes the police report, if you do a public records request, will include photos at the injury site. And you can see in the photos sometimes exactly what happened right after the fact. For instance, if it was a collision between a car and a pedestrian in a crosswalk, and the car stopped right where the event occurred, the police might document that in photos, and that doesn't necessarily show up in the police report. That's really helpful information to have down the road. If you are in the hospital and dealing with a serious injury, that's not something you're going to be focused on. So it's really helpful to have somebody help gather that information as soon as possible. Sometimes you can get surveillance footage from nearby businesses or even the traffic cam footage if the request is made soon enough before the video footage is destroyed. So that's a note on documenting the incident. Gathering medical evidence is another part of gathering information early on in the claim. Some of the key records as you're making a decision on whether you want to pursue a claim or before you engage with an attorney is collecting your important medical records. If you do go to the emergency room right after the injury and you're discharged, getting a copy of that summary is going to be helpful. It is not always easy to get copies of your medical records later down the road. It might take 30 or even 60 days when you request the records to get them. So if you can get your discharge summary when you leave, that is helpful. Getting after the fact, getting copies of CT scan, MRI scans, any sort of neuroimaging with the reports to show what was obtained and what they saw is helpful when you're putting together your claim before meeting with an attorney, or if you're deciding to pursue a settlement on your own. List of medication that's been prescribed to you because of the injury. Staying organized, I know, is really challenging for a lot of people with brain injury. Executive function can be challenged, and takes a lot of energy to put time and effort into that organization. So if someone can help you stay organized, keeping your records in order, scanning the records, keeping an electronic copy if you're able to, storing those copies, that's always really helpful. And if you do have an attorney, giving them everything you've got and letting them organize it for you is a really good way to stay on top of the game before you even formally pursue a claim. A note about requesting medical records: if you do this on your own, there is a HIPAA form that you will have to sign to get your records from your providers. Sometimes they do charge a small fee for you to get your records from the entity. Keep receipts if you pay for that, even if it's $10, $20, you do get that back when it's time to settle the claim. And if you are given a HIPAA medical authorization from someone who's not a medical provider, this is important. For instance, if an insurance company wants you to sign a HIPAA medical authorization so they can get your records, do not sign that until you talk to an attorney. Does not mean that you have to hire an attorney. You can consult with a lawyer to say, I was hit by a car. They were insured by USAA. USAA wants me to sign this medical release. Should I? Have an attorney look it over. it may not be in your best interest to have insurance companies getting access to your medical care if it's really soon in the claim process. So it is totally fine to seek a free consultation with a lawyer before you sign something like that. Symptom tracking is something that, as an attorney, I find really helpful when my clients have done this. Some people keep something like a headache diary, where if you're someone who gets regular headaches, you can rate today was a 2 out of 10, not a bad day for me, or today was a 7 out of 10. I had to stay home. I had to keep the lights low. I had to minimize any kind of sensory input because I just couldn't today. And maybe trying to track what's creating worse headaches, like if you had to do an extra errand, you had to go to the grocery store that day and it was just too overwhelming. Whatever it was, it's nice for the claim if you're tracking that, because sometimes your attorney doesn't get involved for 6 months or even a year after the injury, and showing what you went through during that past year is helpful in proving the damages. Another, if you're not someone who gets headaches, I know that's a major one that a lot of people suffer from. Also, just kind of tracking how your sleep is going, energy level throughout the day. If you're dealing with mood changes, that's not always easy to document because you may not even be aware if your mood changes are not noticeable to others. But if you are dealing with things like short-term memory loss, losing items, having issues with word recall, anything that's kind of at the moment it's noteworthy to you, if you jot it down, that's helpful down the road. I know it's not always easy to kind of remind yourself of the pain that you're in or the symptoms that you're having. So maybe it's something where you check in 2 times a week with your journal and just kind of document how things are going for you that week overall. Insurance adjusters will reach out to you if you've been injured in a car accident or you've had some kind of injury at a commercial presence, like a premises, like a store. They will reach out to you pretty quickly. It is best to be very polite on the phone, but if you can, just keep the call as short as possible. They will want to record your statement on the phone. You can politely decline and say, I'm not in a position to speak with you right now on a recorded line. It will not hurt your claim if you don't speak to them. Under the law, your claim is open for 3 years in Washington state from the date of the injury. The adjuster may try to be nice to you on the phone, but they are not your friend. They are trying to settle the claim as quickly and for as least amount of money as possible, which could mean settling short and impacting your ability to get medical care. So if insurance adjusters do start calling you, or if you're a caregiver and insurance adjusters start calling and wanting to speak to your family member or friend who has been injured, it is best to just say, tell me what you need to know. We will get back to you. And then reach out to an attorney for a consultation to say, insurance adjusters are calling. This is the company they're calling from. Should I talk to them? And if so, what should I disclose? Again, as I said earlier, if any releases are provided to you by insurance companies, don't sign anything until you've consulted with an attorney. I have seen cases where insurance companies have taken advantage and had someone sign a release for a very small amount of money within a few weeks of an injury, and that completely closes the claim. And this is someone with profound injuries who signs a settlement for not nearly enough money, and that means they will not have access to care going forward. Throughout the process, you may be asked to do an evaluation by an expert. One such evaluation is a neuropsychological evaluation. Sometimes it's just called neuropsych testing, which is short for the neuropsychological evaluation. This can be a very useful tool using standardized testing to show how your memory is, how your attention and focus are post-injury, and really just how you're functioning well with your activities of daily living. The testing can be very involved. Typically, it's a full day of testing. For some people, it has to be done over a few days because it does involve a lot of energy and focus. If you have an attorney who is sending you for neuropsychological testing, that would be to help kind of support your injury claim. If the defense or insurance company is sending you to a neuropsychological testing, that's because they're trying to look into ways to defend the claim. Either way, if this type of testing is coming up, you probably already have a rehab physician, a neurologist, or a primary care provider who has sent you for that neuropsychological assessment. And you can get some good, more detail about, hey, what's involved in this testing and how do I prepare for it and what am I really doing here, just so you have some more clear insight into it. A wonderful thing that can come out of the testing is a treatment plan that specifically addresses your personal deficits and how that can help you improve your function in life going forward. Another expert that comes up in the legal claim process is a vocational expert. And some of you may have worked with vocational experts in your experiences as well. These are folks who are licensed in the area of kind of job analysis. And what can you do? What were you doing as a profession before your injury? What can you do now? Are you now limited in your career? Or are there things that you can do, but you have to do in a smaller capacity? Or is working really not something that you're able to do right now? That's something in the legal world we have to do to prove the economic part of the damages on a brain injury case. So dealing with a vocational expert is something you can expect if you're pursuing a legal claim for a TBI. And similar to a neuropsychological assessment, a vocational assessment does involve standardized testing and an interview portion to kind of talk about your vocational history, educational history, and ability to work. If you're not able to work, then there will be an extra piece about maybe some additional resources that'll be needed to help you. So I alluded a few times to if you have an attorney or if you don't have an attorney and you're pursuing a legal claim, obviously nobody plans on getting a traumatic brain injury. Nobody plans on getting injured when they wake up one day. So no one has an injury attorney just kind of on retainer. It's not a planned event. If you do find yourself in a situation where you've been injured or someone in your family has suffered traumatic injury, then obviously getting treatment is going to be first on your priority list. Eventually, you will probably want to consult with an attorney. And again, it's probably not the first thought that crosses your mind, nor should it be. But if you are getting calls from insurance adjusters, if you are worried about your ability to get treatment, for instance, if insurance is not available to you, or if you don't have the ability to return to work, or you just aren't sure how this process works, you can call an attorney. And it doesn't mean that you are filing a lawsuit. It doesn't even mean that you're hiring an attorney. You can call an attorney who specializes in TBI claims and who specializes in injury law. Some attorneys do everything. They do divorce, criminal law, contracts. If that is the type of attorney that you know, probably not the right person to call if you have a TBI. You want someone who only does injury work and specifically specializes in TBI so they can appreciate who the appropriate medical experts are that you should be seeing specific to your situation. And also, you want to make sure that they can communicate with you, appreciating the difficulties you might have with communication. When you decide which attorneys to consult with, you can start with groups like this. Ask your friends in your support groups who have been through a similar situation. Ask your doctors that you trust. If you have someone, a counselor, a rehab physician, a psychologist, anyone who understands your injury, ask them if they can recommend someone or if the person you want to talk to sounds like the right fit for you. When you do talk with an attorney, make sure they have experience in your type of situation, and also understand their communication style. Are they willing to meet with you where you're at? Meaning, are you only comfortable over the phone, or maybe you're only comfortable in person? Maybe email doesn't work for you, or maybe you only want email. Whatever your situation is, you want to make sure that the attorney understands how your communication style is and that you need to be understood, you need to be heard, and you need to understand what's being said to you. A lot of people say, I want to call a lawyer, I can't afford that. If it's an injury situation, you do not pay for a lawyer. You don't pay for their time up front. You don't pay a retainer amount to talk to them. You pay an attorney on an injury claim only if there's a settlement, and they get paid a portion of your settlement if it's successful. So, example, if you call an attorney and talk to them for 2 hours, they're not going to send you a bill. That consultation doesn't cost you money. If your case settles and there's a successful settlement, then you pay the attorney a percentage out of that settlement. And that's something you agree on when you hire them. And that meeting should be in person if you can make it in person, and you should have a really clear discussion on what that percentage is. So if you do an attorney consult, what are you going to bring to that meeting? A medical summary. So as I mentioned earlier, gathering your records, if you have them, bringing that medical diary, if you have that, or even just a single post-it note with the bullet points of the treatment that you've had, because it's really overwhelming in the meeting and you may forget some key items. So coming in with notes prepared will be helpful, as well as all of the doctors that you've seen that you can recall. Have a clear timeline on when the actual injury occurred and key events from that time. For instance, if you ended up having surgery, if you were in a rehab center for a period of time, if you had to wait 6 months to see a neurologist, when that visit was, and what they recommended. Big events that you can remember. And then the amount of your medical bills or expenses or time loss from work. If you have a good sense of that, those are good things to have written down before the meeting with the attorney. It is okay to bring someone with you to a meeting with an attorney. In fact, I highly recommend it. It helps you remember what was said, and it also helps your attorney to make sure that everyone's on board and there's an understanding on what's happening. If you do bring someone with you, make sure it's a trusted person in your community, that you are okay with them hearing about your confidential medical issues, and you trust them to relay to you what happened in that meeting later if you're having difficulty remembering. If you do bring someone into that meeting with an attorney, you want to disclose to the attorney, I need this person here to take notes for me. A good attorney will then have that person sign a document that says, I'm here as an agent of the injured person, so the attorney-client privilege is not in any way impacted. And you can certainly request communication accommodations. A good attorney who understands traumatic brain injury cases will ask how they can accommodate any sort of communication issues, but you also just want to make sure that it's clear if you need repeated summaries, if you need a follow-up email with a written summary of the meeting, if you need any kind of visual aid, graphs, charts, whatever it is that helps you, you want to make sure that they know this. So if you do get an attorney involved to help with your claim, you want to make it clear that they're checking in with you regularly. A lot of complaints that I hear from people who have hired attorneys and it's gone south say, I just never hear from them. I don't know what's going on with my case. They don't return my phone calls. So make sure you have a clear understanding after that first meeting if you're moving forward. When am I going to hear from you next? And how am I going to hear from you next? And when do you want me to check in with you? Is it after every single appointment that I have, or just after every appointment with my rehab doctor? Do you want to hear from me weekly? Do you want to hear from me monthly? have a really clear case plan outline, and also have a clear timeline on when you can expect your claim to be resolved. Resolution of the claim requires proving damages. And so there are a few different pieces to a claim for damages. One is economic damages, and those are really easy to substantiate. It's the amount of your medical bills, it's the amount of your income loss, and it's the amount of your future medical bills and future income loss if you require ongoing care. Non-economic damages, that's this concept called pain and suffering. And everyone's heard of pain and suffering, but nobody really knows what it means. It's vague, and it is very specific to your situation. So it does include physical pain that you're dealing with and suffering as a result, but it also includes what you've lost, the impact to the quality of your life, your relationships with loved ones, your enjoyment of life and independence. Emotional distress that comes from dealing with a brain injury is huge. And then your future damages would include things like ongoing care needs into the future. And if you need any kind of um, assistance around the house, technology wise or mobility wise. All of that is included in your legal claim. When proving your legal claim, it is very helpful to speak with your family members and friends that know you well. They can give statements about your quality of life day to day and how things have been impacted. Sometimes what we do is we ask trusted friends or family members to give us a statement about what you were like before the accident versus after, to kind of help prove the overall massive impact. Just an MRI or just an X-ray is not enough to prove the case. We want to tell the story in an impactful and meaningful way. And we can do that with video footage, photos, or even coming to your home environment to then document the modifications that have been made to really accommodate the injuries that you have suffered. Proving the economic damages, that would be through things like your tax records, medical bills and receipts, costs for in-home care, and then we would give all of that to an expert to show in their vocational report or what's called a life care plan if you need future medical cost accommodations. So after all of that information has been obtained, you will be faced with the choice of either settling your case or going to trial. Settlement is faster. You get an offer from the insurance company, you agree, you sign a release, and then the case is resolved and you have funds. Sometimes that's done through what's called mediation, where a neutral mediator, often a retired judge, comes to the proceeding and through a voluntary process kind of goes back and forth between the insurance company and you and your attorney to see what amount would be successful and acceptable for you to live on. If the amount is not sufficient, or if the insurance company is not negotiating in good faith, your other option is going to trial. Going to trial involves going into a courtroom in front of a judge or a jury or both and having them determine what the amount of your damages are. Sometimes that's the only option. It is very rare. Most cases, over 90% of cases, settle outside of trial. But if you do need to go to trial, you want to make sure you have an attorney who is an experienced courtroom litigator, someone who actually goes to trial, doesn't just settle cases. When you get a settlement offer, how do you know if it's good? Well, you want to look at what are your future medical needs. Are you looking at rehab for the rest of your life, or are you done with your care? Are you looking at the need for income to help you live going forward, or are you back to work? Those are really, really big issues you need to make sure you have a good handle on before deciding to settle your case. It is nice to have peace of mind and closure and not have an insurance claim hanging over your head anymore. That is worth a lot, but you need to make sure that that number that you agree to will cover you into the long term. Sometimes a settlement includes what's called a structured settlement, where you get payments every month for the rest of your life, and the rest of the funds are invested. And so you're getting some kind of growth on the actual settlement. That is an option for some people, but you want to make sure you're talking with your attorney and financial experts that your attorney can bring in to make sure structured settlement makes sense. Sometimes with younger people, we recommend a structured settlement so they can get small payments over their lifetime, because maybe at the age of 19 or 20, a really big settlement is not the best thing for someone that doesn't have maybe the best financial judgment. So a structured settlement can have some safeguards in place so the funds will grow and the person will still get some payments in the short term. When you're making that decision about settling a case, involve your people. Do not make it on your own. Have a trusted advocate in the room with you and ask for plain language. Don't let anyone talk over you with big terms that don't necessarily make sense. You want to make sure you know what medical bills are getting paid out of your settlement and how much are you actually getting from that settlement. And if you don't have anyone in your home or family or small network that you trust, you want to make sure your attorney is answering those questions for you. Some practical tools involving the legal claim: reminder, building your file and staying as organized as you can. Practice conversations with adjusters or attorneys in a safe and supportive setting. I'm sure that you all talk in support groups or among yourselves, but you'd be surprised how many people have actually been through this. And there are things you can learn by leaning on others. And having that personal checklist to make sure all of your items are identified is really crucial in helping with your claim and meeting with your lawyer. Emotional support and benefits planning, it is really important before you settle a case. If you are receiving SSDI, if your treatment is through Medicaid, if you get housing benefits, you need to know how those will be impacted when your case is settled. Getting a financial settlement will impact your benefits. So there are ways, by putting funds into a trust or otherwise consulting with an appropriate benefits attorney, that you don't want to get a big settlement and then suddenly you no longer have Medicaid. You need Medicaid to cover your care, or you no longer have assistance with housing. So anytime there's discussion about a settlement and you have benefits, make sure that your attorney is putting you in touch with the right benefits coordinators and financial people to ensure that your money is protected and your benefits stay intact. So we're ready to open this up for questions. I do want to put my contact information on the screen, so I'll give you all a moment to write that down or take a screenshot. I am available to any kind of personal questions that you don't want to share in the group today. There's my email address and my phone number, and I'm happy to provide any kind of advice or consultation that I'm able to if you have questions that we're not able to get to right now.
Thank you, Melissa. I'll ask you to, oh, that's great. That's super. Let me just turn off the recording, everyone. Hold on here.